Hey everyone, welcome back to the channel. Today we are diving into the fascinating world of confidentiality clauses. Whether you are a business owner, an employee, or just curious about legal matters, understanding confidentiality clauses is crucial. First, what exactly is a confidentiality clause? Essentially, it's a provision in a contract that obligates one or more parties to keep certain information confidential. This clause is vital in protecting sensitive information from being disclosed to third parties. Now, let's break down some typical provisions you might find in the confidentiality clause. Number one, definition of confidential information. This part of the clause specifies what information is considered confidential. It could include trade secrets, business plans, customer lists, supplier lists, financial data, and more. The definition needs to be clear and comprehensive to avoid any misunderstandings. The second clause that you will find in the confidentiality agreement is the obligations of the receiving party. This provision outlines what the receiving party must do to protect the confidential information. It may include instructions on how to store the confidential information, limits on who can access the confidential information, and measures that are required to prevent the unauthorized disclosure of the confidential information. The third clause that you see is duration of the confidentiality obligation. This specifies how long the confidentiality obligation lasts. It could be for a fixed term such as 5 years, or it could continue indefinitely until the information no longer qualifies as confidential. It is common in confidentiality agreements to see a clause called permitted disclosures. There are often exceptions to the confidentiality obligations. For instance, the clause might allow disclosure to employees or agents who need to know the information in order to perform their duties, provided that they also agree to keep it confidential. Speaking of exceptions, let's look at some common scenarios where confidentiality obligations might not apply. Number one, public domain. If the information becomes publicly available through no fault of the receiving party, the confidentiality obligation typically ends. The second most frequent exception is legal requirements. Sometimes the law requires disclosure of the confidential information. So for example, if a court of law orders the disclosure of the confidential information, the receiving party must comply with the court order, although they should notify the disclosing party beforehand if possible. The third most frequent exception is if the receiving party already knew the information before it was disclosed under the confidentiality agreement, they are not obligated to keep it confidential. The fourth most common exception to confidentiality obligations, third-party sources. If the information is received from another source without the confidentiality obligation, the receiving party may not be bound by the confidentiality clause. So let's wrap up with some best practices for drafting a confidentiality clause. First, be specific. Clearly define what constitutes confidential information to avoid any ambiguities. Second, include reasonable exceptions. Make sure to outline exceptions to ensure that the clause is practical and enforceable. Third, ensure mutual understanding. Both parties should fully understand their obligations and the scope of the confidentiality clause. And that's all for today, folks. I hope this breakdown helps you understand the key elements and exceptions. If you found this video useful, please like, share, subscribe to my channel for more legal insights. Thanks for watching, and I'll see you in the next video.